Donald Trump's presidential immunity has been denied by guess who? Oh, Judge Chutkan. We weren't expecting much out of this courtroom, but this one came down, and it's not only the motion to dismiss the January 6th prosecution brought by Jack Smith based on presidential immunity, but she also wrapped in there another issue that we've talked a lot about here, which is the constitutional basis for dismissing the case. And there's all sorts of reasons why what Jack Smith was alleging that Donald Trump did, what he said was criminal in the indictment, they said it's not criminal. The Constitution protects things like free speech, free expression, free association, and Jack was trying to criminalize free speech. So Chutkan kind of wrapped up both of these issues into one motion, denying the motion to dismiss. It's a 48-pager. We'll take a look at it. And we'll follow it up with some other J6 psychos like Cheney, who is out here on her book tour after she got thrown out of Congress. Embarrassingly bad performance there in Wyoming. And Donald Trump will respond to Liz, who's talking about her TDS, which we know she has. So we're going to get right into the motion and see what's coming out of Judge Chutkan's courtroom. Again, January 6th, Washington, D.C. Trial scheduled for March, okay? We've got one day before Super Tuesday is when we're going to have Chutkan holding trial. And so Trump, of course, is going to be appealing all of this, and we're going to have a bunch of back and forth on a lot of these issues. But this is the memo. This is the order, which is just the one-pager. It says, all right, for the reasons set forth in the accompanying memo, here, Donald Trump's motion to dismiss based on presidential immunity, which was its own filing, which we read, and Donald Trump's other filing, motion to dismiss based on the Constitution, which they don't care much about here, is denied. Both of them denied, right? So she wrapped them up into one. Now, this is from Tanya Chutkan, United States District Court judge, the same judge who refused to recuse herself despite making statements adverse to Trump when she was sentencing other J6ers, saying things like, I wonder why the person responsible has not been, indicted or standing before me or something like that, right? That somebody else was out there. We all go, who is she talking about? Who's the only other person? Oh yeah, it's Trump. So we know where she stands on this. Now, this is the memo. You can see it's a 48-pager out of DC. We're going to hit the highlights on it. You see, this is from Judge Chutkan writing to both parties, and this is a big one. We have, just as a little quick note, we also have other pending motions to dismiss that are very likely going to be denied, as we predict. So here, this was the constitutional motion. We know there's also a statutory motion to dismiss. We also know there's motions based on defining the scope of Jack Smith's team that are going to be relevant for discovery and so on. So here, the judge says, as we expected, the court will deny both motions. All right. So here's what the judge says. Listen. Now, at the motion to dismiss stage, the court assumes the truth of the indictment's allegation. And this is true, right? This is just regular stuff in criminal law. A motion to dismiss a government's indictment is a tough bridge to cross, right? They don't just dismiss cases. So they're going to say that everything in the indictment is true. And if we believe that everything is true and you can overcome that, then it'll be worthy of a dismissal. But you can imagine that's a tall, tall burden. So Chutkan writes, here, Trump contends that the charges in his indictment are based on his public statements and tweets about the election and its certification. He says it's about communicating with the DOJ. He says it's about talking about appointing things like AGs, all with which are within his duties. They say communications with state officials about the federal election and the exercise of their official duties with respect to the election also are included, saying that Trump was just talking to the VP. Trump was just organizing alternate slates of electors and other things. And those things don't sound like criminal. We see here that Chutkan continues, says those generalized descriptions from Trump and his defense, they fail to properly portray the conduct with which he has been charged. Accordingly, I'm going to give you my interpretation of what he's been charged with. So she doesn't like Trump's characterization of the indictment. So she says, let me show you what I think it is. All right. Okay, Judge, here we go. She says defendant Trump was the 45th president running for election. Now, despite having lost that election, she says, he was determined to remain in power. And she's all just citing the indictment. Okay. All of these are indictments. She's basically reading from the indictment again. Okay. We don't need to read it all. So she says here, right? He knew what those claims were false. He widely disseminated them anyways. He made knowingly false claims that appear legitimate. I think they're gonna have a real tough time proving that. That's the mens rea. That's the mental state. How do you get inside Trump's head and tell us that he knew that the election was truthful and honest and definitely not rigged, but was just lying to us? How is that possible? Because we fast forward now in 2023, going into 24, and suddenly there's a lot more evidence that it was rigged. And we're all pointing our fingers back at these people who are saying this and saying, we told you so. See, here it is. So she says that Trump also pursued unlawful means of discounting legitimate votes and subverting the election results. Specifically, he targeted a bedrock function. Okay, now we're asking ourselves, like, what is the conduct? We have to distinguish between speech and action and speech and conduct. And so what is he doing? He's targeting a bedrock function, which is the certification of the results. And she says the indictment tells us how the ECA works. And of course, we know that the Electoral Count Act, the ECA, it was all modified after the fact, right? Trump said that Mike Pence had a thing that he could do. Now, we were here on the record saying, I'm not so sure about that, right? I think that's kind of questionable, but it is questionable. That's the point. It wasn't clear. And you can always make that argument. In fact, that's what lawyers do every day, is to take ambiguous statements and drive a truck through them. So that's what Trump was doing. That's what his lawyers were doing. And we know that you could drive a truck through it because they patched the hole up after the fact. After Mike Pence, this is what the vice president does. We don't want that to happen again. Let's make it ultra clear because it wasn't in the first place. So they say Trump, okay, along with 6 co-conspirators, undertook efforts to impair, obstruct, defeat that process through dishonesty, fraud, and deceit. Now, that took 5 forms. 1, false claims of election fraud, which is all speech and opinion, and I think he's entitled to make those things. They said baseless fraud claims. I totally disagree. What are you talking about? Defendant pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters. Yeah, but that's on the pretext that the election was fraudulent. Hello. In other words, it's not ignoring the popular vote. It is having an actual election. And the fraud election would show that the popular vote is not what you say it is. That's the point. Dismiss legitimate electors, right? If the election was what we say it was. And the same thing goes on. You can see the pattern. Then they organize false slates of electors, which happens all the time. They've done it many times. Democrats have done this even back in the Nixon-Kennedy race in Hawaii, I believe that, or LBJ. Now here, then they cause these fraudulent electors to transmit their false certificates, as they do in all contested elections. Nobody else has been indicted for it. Third, they attempted to use power and authority of the DOJ to conduct sham election investigations. So they're mad that they weaponized the DOJ. Is that what they're saying? Yeah, all right. So they don't like that they were investigating electoral fraud. Now they call it a sham. I don't think it was a sham. I wish Bill Barr would have done something about it, quite frankly. And a lot of these people, we were screaming from the rooftops about them changing the rules, right, before it even occurred. What happened in Michigan where the FBI came up and seized all those strip mall operations and just bundled those up and threw those in the garbage disposal? What happened to those? All right. So fourth, using knowingly false claims of election fraud, they attempted to convince the VP to use Trump's fraudulent electors, reject legitimate electoral votes, and send these for the states to review, all which was articulated as a process that could have been contemplated. And even Ted Cruz was calling for a pause, right? A lot of things were happening, which is why they needed to set off the distraction event, which was J6. So the judge says, all right, I've summarized it again. She probably really enjoyed that. It's probably like a, late night cup of wine, drafting this thing up. Oh gosh, it's like a romance novel, So based on the conduct, the indictment charges Trump with 4 counts and so on. Here's the legal standard says, all right, when the defense moves to dismiss the indictment based on some sort of a defect, we've got to make sure we're doing our due diligence on this thing, right? We don't just dismiss cases here. Judge Chutkan continues. She says, all right, here we're going to address executive immunity first, presidential immunity. Says that Trump contends that the Constitution grants him absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. Okay, think of this almost like qualified immunity for the police. They do something within the confines, you can't sue them. Trump's saying same thing here. He says, I served as president so long as he was not both impeached and convicted for those actions. And we've talked about this here many times. Constitution says that you impeach first in the House, then you convict in the Senate, and then once that is done, once both of those things are happening, then the conviction stands and the person is then subject to the other prosecutions that you'll find elsewhere in the country for the actual crimes. But you do that so you make sure that it's not political, it's not partisan, right? You got to have a 2/3 vote to convict in the Senate. It's a much higher standard. So you give him the literal indictment and conviction. And you don't want all of the rest of the AGs and all these people to leapfrog over and just indict the president, right? Somebody just indicts the president and they can take him out of play. So the proper mechanism for indicting a president for his presidential conduct is through impeachment and conviction. Happened twice. They didn't get him. So now they're defaulting to something else. So Chutkan continues. He says, well, the Constitution's text and structure and history don't support that contention. She didn't really hardly explain it. No court or any other branch of government has ever accepted it. And this type of stuff that you hear is just wild, right? Do you know why? Because has a president ever been indicted? And has anybody in the history of the entire country ever made this argument? No, this is new, right? When's the last time a president been indicted criminally in the United States multiple times by these people? Never. And this court will not so hold. Well, thanks. So she's saying nobody else has ever done it, so I'm not going to do it. You say, well, you're the first one with the case. Whatever immunities a sitting president may enjoy, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. That's fun, Chutkan. Former presidents enjoy no special conditions on their federal criminal liability. They don't? It's in the Constitution. They talk about impeachment for high crimes and misdemeanors, and there's a whole process that's articulated. Let's see what she says. She's going to go through this. We'll watch. Former president, she says, Trump may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. So she's setting this new standard here out of the court. And this is, like this could be a historic case, honestly. I mean, but she is picking the standard that she is going to try to etch into the history books, that presidential immunity does not exist for criminal conduct. I mean, this is a great precedent, by the way, for the DOJ, the FBI, and all of the other agencies who might want to control a president. Because if they just indict him, it puts the pressure on the president to be subject to the whim of any other prosecutor anywhere. They just prosecute him and that's it. So the whole point, and this is one of the dumbest phrases we've been hearing here, and I've been saying this for months now, that when they say that the president is not above the law, literally, yes, he is. Literally. He has the pardon power. He has the opinion power. He's the commander in chief. He can just order people to go into battle and die, right? Somebody gets a conviction. He says, no, you're wrong. Pardoned. Gone. I'm above you. And it's all articulated. We've gone through this many times. And with that, okay, because you need the logic of somebody who is the chief executive of the entire branch of the federal government, which is supreme to the rest of the duality that we have here with the states, that person has to have a root position. Otherwise, it doesn't work. Otherwise, the people, this is a benefit for American democracy, by the way, so that if we say exactly what is happening right now, if we say that the deep state, the DOJ, whatever you want to call it, right, the blob in Washington, if they've become corrupted, we want to be able to supersede them with our vote and install our candidate to clean up the mess. That's the whole point. But if now we can just say we get Donald Trump elected and then they just indict him again, first day in office, and indict him again, indict him again, indict him again, and it derails the whole thing. The standard is insane, right? But she is cobbling this together because it's Trump. So let's get into it. Obviously, it's illogical, but here's what she says. In interpreting the Constitution, courts ordinarily begin with its text. Let's see what she does. But there's no provision in the Constitution conferring the immunity that the defendant claims. Well, we would say it's in the impeachment provision. Let's see if she even talks about it. The Supreme Court has already noted the absence of explicit constitutional guidance in Nixon on whether the president possesses any immunity. The executive branch has likewise recognized that there is no explicit immunity from criminal sanctions or any other officer. Again, like none of this has ever happened before, right? So all this is kind of, you get the gist. There is no presidential immunity clause, says the judge. And the lack of constitutional text is no accident, says the framers explicitly created immunity for other officials, right? Of course. And the Constitution speech and debate clause provides that senators, representatives shall in all cases except treason, felony, breach of the peace, be privileged from arrest during their attendance. And so, okay. So she's given us some other examples for like legislative immunity. Great. Speech and debate. Got that. And others protected governors until they were out of office and so on. Nor is the Constitution silent on the question because its drafters or ratifiers assume the president would enjoy immunity. Of course not. But you have to go through the impeachment mechanism. I'm going to blow a gasket if she doesn't get to it. All right. I better calm down and let's just see if she gets to it before I blow a gasket. All right. To the contrary, America's founding generation envisioned a chief executive wholly different from the unaccountable, almost omnipotent rulers at the time. Wow. She's going to take us into the Federalist Papers. That's nice, Judge. Okay. You don't need to go back all that far. All we need to know is about impeachment. Okay. Here we go. Finally. All right. Calm down, Rob. Lacking an express constitutional provision, Trump hangs his textual argument for immunity on the impeachment clause, but she says it cannot bear the weight. Here you go. Judgment in cases of impeachment, which as we know is for high crimes and misdemeanors, shall not extend further than to removal from office and disqualification to hold and enjoy office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable, right? Convicted, ED, and subject to impeachment, trial, and punishment according to the law. So about as clear as I can see on the face of it. Impeachment does not go further than to removal of office and disqualification. So you're impeached first, but after you're impeached, but the party convicted, so again, House of Representatives, then the Senate, shall nevertheless be liable. So you got to go through those things first, but then not. Now, from this language, Chutkan says, Trump concludes that the president may be charged only by indictment in cases where the president has been impeached and convicted by the Senate. But Trump is not president, and reading the clause to grant absolute criminal immunity to former presidents would contravene its plain meaning, original understanding, and common sense. Amazing. So she's just going to take Trump's status now and say that doesn't apply to him. It's so insane because the conduct that they're saying, he was still the president on January 6th, by the way. So here she says the clause has two parts. The first limits the penalties of the impeachment to removal and disqualification, and then opens you to criminal liability. That limit marked a deliberate departure from British tradition, and she's going to lecture us on that. Both parts of the clause undercuts Trump's interpretation of it. The first clause begins by defining the clause's scope, judgment in cases of impeachment, okay, indicating that the clause is aimed at identifying the permissible penalties associated with impeachment itself. The second case confirms that purview. Rather than stating that the party convicted shall only then be liable, the clause states that the party convicted shall nevertheless be liable. At the founding, as of now, nevertheless means notwithstanding. Notwithstanding, that meant without hindrance or obstruction from. Okay, so do you see how she just like changed that word right in front of us? She says, well, I went back and I found a different word. So nevertheless means notwithstanding, and notwithstanding that without hindrance or obstruction from. So incredible. Rather than stating that the party shall only then be liable, Constitution says nevertheless be liable. And so that word is just what that means. And so she can just swap it in there. So the word says in the impeachment judgment clause, the word nevertheless in the second part thus signifies that the first part, constraining the impeachment penalties, does not bear on whether the party would also be subject to the criminal prosecution. Wild. It means like the exact opposite of how it reads. Isn't that incredible? Watched her do it. So she says, as discussed below, the clause's manifest purpose and the originally understood effect was therefore, she says, to permit criminal prosecution in spite of the prior adjudication by the Senate and to forestall a double jeopardy argument. That's quite a different situation, she says, than establishing impeachment and conviction as a prerequisite. And she says, what Trump cites doesn't move the needle. He talks about Alexander Hamilton saying in the Federalist that the president, in that Federalist paper, Hamilton said, the president of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes and misdemeanors removed from office, and would afterwards be liable to prosecution in the ordinary course of the law, right? Which is a perfect explanation of how this phrase worked. Thanks, Alexander, for explaining it. That makes sense, right? You go through the political process first before you just turn the person loose to the other justice systems. Would afterwards be liable, and punishment in the ordinary course of the law. So it's unordinary, right? It's different. First, it's like a political review. You know, hey, we're going to do a review now for you. And if we found okay, then you're going to be subject to greater penalties. Okay. And you go through it. Here, what the judge says, and that the president would at all times be liable to impeachment, trial, dismission, incapacity to serve, and to forfeiture of life and estate by subsequent prosecutions in the common course of the law, right? After the fact. But the judge says, I don't like those statements. She says, those statements merely echo the clause's clarification, okay, clarifying this, that the prosecution may follow impeachment. Not that they have to, they may. They do not say that those events must happen in that order. We don't have to go through an impeachment if we don't want to, and she just gets rid of it like that. Second, Trump cites founding father James Wilson's remark during the ratification debates that the president is amenable to the laws in his private character as a citizen and his public character by impeachment. But Wilson was referring to a president in office, and that's entirely consistent to a president returning to public life and that being subject to criminal prosecution. She says there is no evidence that any of the Constitution's drafters or ratifiers intended or understood former presidents to be criminally immune unless they had been impeached and convicted. That's literally what Hamilton just said, much less a widespread consensus that the impeachment judgment clause would have that effect. She literally just cited it. There's no evidence that they drafted or intended them to be criminally immune. Like, they didn't say that phrase, but you can just read this out of the text. Here is what Hamilton said. Afterwards, he would be liable to prosecution and punishment in the ordinary course of the law. So if this person, let's just add a not, or let's just reverse the phrase, if the president of the United States is not liable under impeachment, then there is no afterwards, okay? So if he is not impeached, tried, and convicted, there is no afterwards of that. And she just says that that is no evidence that he had that opinion. It's bizarre. It's like page before, Judge. It's right there. Look, I'll draw a red line for you. Right up here. We'll just keep going. Up, 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 up. Come on. Right there. It's right there. Afterwards. Good Lord. There's evidence. Okay. So in addition to lacking textual or historical support that is on the preceding page, Trump's interpretation of the clause collapses under the application of common sense. Okay. Let's see. For one, his reasoning is based on the logical fallacy of denying the antecedent. Oh, gosh. Here she says from that statement, if the animal is a cat, it can be a pet. Okay, so you see this here? This is word games now. But defendant argues that because president who is impeached and convicted may be subject to prosecution means that a president who is not convicted may not be subject to criminal prosecution. But even assuming the negative implication finds some traction when applied to sitting presidents, the logic does not hold for former presidents. Okay, so now she's going to time exclude him. That's because there is another way besides impeachment and conviction for a president to be removed from office and thus subject to the ordinary course of the law. The president shall hold his office during the term of 4 years. And so she says the expiration of the term ends that protection. Nothing in the impeachment clause prevents criminal prosecution thereafter. It's really disgusting. It's the same conduct, right? The January 6th case is the same conduct that he was impeached for, that he's being indicted for. So they say Trump's reading of the impeachment clause also proves too much. He read too much into it. If the clause required impeachment and conviction precede criminal prosecution, then that requirement would apply not only to the president, but also to the vice president and all civil officers of the United States who may likewise be impeached. So now she's saying if I read it too broad, then it makes illogical sense. And finally, says Judge Chutkan, Trump's interpretation of the impeachment clause would produce implausibly perverse results. And let's see, says the Constitution permits impeachment and conviction for limited categories of offenses, high crimes and misdemeanors. Oh my gosh, this is wild. So now she's going to say if we read it this way, then Trump's crimes would not be prosecutable. Under Trump's reading, if a president commits a crime that doesn't fall within one of these 4 categories, treason, bribery, high crimes, which I don't know, you could say felonies, and 4 misdemeanors. So if any one of those is not included, then he can't be prosecuted at all. But if Congress does not have an opportunity to impeach or convict a sitting president, perhaps because the crime occurred near the end of their term, or is covered up until after the president has left office, well, that's a separate issue. You could always make the argument that the president can be impeached after he has left office, if you want to go that route. She's saying that there is a gap in prosecution that a president could escape. He could commit a bunch of crimes at the end of office and then not be prosecuted. Says the former president could similarly not be prosecuted. Says defendant seems to suggest that this scenario in which the former president would be utterly unaccountable for their terms is simply the price we pay for separation of powers. And she says that cannot be the clause's meaning, which is not what anybody's arguing, right? But she's saying if I interpret it this way, I could get there. And so therefore I can't interpret it that way. But my interpretation, I think, also leads to even more perverse results, what we're seeing actually right now. Now, she doesn't think they're perverse because it's the prosecution of somebody that she detests and that the left is on a mission to remove. But the perverse results here are that any president can now be indicted, as long as anybody can just make up a charge, essentially, for whatever. No immunity. And if you can make the claim that there's some, personal overlap, there's some non-presidential conduct, that you can bypass Congress and the impeachment proceeding to just go straight to an indictment. It's a perverse thing. She's opening the door, essentially, political prosecutions in America. Since they started it, they're like, well, we're allowed to. In sum, this is Chutkan wrapping up, says, in sum, nothing in the Constitution supplies the immunity that Trump claims. I agree. There's no affirmative statement. The president has immunity from corrupt hack prosecutors, but they articulated what the impeachment mechanism was to prevent against that. And she just got rid of it. So to be sure, she says a specific textual basis has not been considered a prerequisite to the recognition of immunity, but the lack of the supporting constitutional text does mean that a former president's federal immunity must arise entirely out of concerns of public policy, essentially as illuminated by our history. And she says the defendant's resort to those principles fares no better. And so that's Judge Chutkan. Okay, she goes on for another bunch of pages articulating. She says, finally, for the indictment to comply with due process, the prosecution bears the burden to provide examples where similar conduct was found criminal, and says here, under that theory, novel criminal acts would never be prosecuted. And so the Constitution doesn't constrain the executive branch for allowing them to do what they're doing. And so all said and done, for the foregoing reasons, Chutkan, as we expected, denies both motions. Motion to dismiss on presidential immunity, motion to dismiss the indictment based on constitutional grounds, and we already saw the order. And so undoubtedly, Trump will be appealing these to the DC Circuit Court of Appeals. We'll see what they say. I think we probably know where that one's going to go as well. And then we'll see what happens at the Supreme Court, where all of these cases will be bound. Now, the big question is, do we get some something from them before March. That seems to be a long shot in my estimation. Unless they accelerate, the SCOTUS accepts this thing and accelerates it, I'm not sure. We'll see. Now, here is Liz Cheney talking about just how dangerous this is. So Donald Trump has no presidential immunity, has no constitutional protections, according to Judge Chutkan. Liz Cheney's out there selling a bunch of books, trying to get people to think that she's relevant after she got obliterated in her last election. Shout out to Harriet Hageman. And here is Liz Cheney talking about that if Trump is elected, he's going to stay in power forever, even though he left last time. Here's Liz. Gosh.
Darkest terms, we will be voting on whether to preserve our republic in the next election. You think this is a vote about whether or not we still have democracy in this country?
It certainly is, and Donald Trump has told us exactly what he will do. He will not abide by the rulings of the courts. He will certainly appoint people to office, whether or not they can be confirmed by the Senate. He has talked about using the military in terms that really are fundamentally un-American, including here in the United States. So it's a very dangerous moment, and it's a moment for people to understand that cannot be the path that we go down as a country.
Just yesterday in an interview, you said fundamentally there's a choice to be made. You can't be both for Donald Trump and for the Constitution. You have to choose.
Yeah.
A vote for Donald Trump is unconstitutional, anti-American.
Well, he won't support and uphold the Constitution. We've already seen what happened. He is the only president in American history who attempted to overturn an election, who attempted to seize power.
That's not true at all. He was trying to contest a rigged election, which we know is rigged by the CIA, by the media, by the FBI, and many others. And so this is hilarious because Liz Cheney is articulating all the things that they've done. I mean, she says like Trump doesn't respect the courts or something. Or like Joe Biden, he just does things. Like, remember student loans? Like, remember those things that Joe Biden just does out of his own? And, a totalitarian, tyrannical government? What FBI raids were we having of Democrats back during the Trump years? Was that happening at all? No, they were roaming the streets, torching cars in Minneapolis. Okay, none of this was happening. The tyranny that we're seeing, the rounding up of American citizens, by the way, by our own government is happening under the Democrats' watch. Liz Cheney's a part of it, but she's going to lecture us about tyranny? Yeah.
To stay in power after he had lost. And the reason that we didn't have a much more serious crisis was because there were people around him who stopped him. Because there were people around the country, state officials, for example, who stopped him, who did not yield to the pressure that he put on them to change votes from Biden to Trump. We won't have that safeguard again. And he's so dangerous. If you have a president who is unwilling to abide by the rulings of the courts, who's unwilling to uphold the Constitution, then there are no guardrails who can stop him.
You've said we're sort of sleepwalking into dictatorship in the United States. Dictatorship. Is that what we would have if we re-elect Donald Trump?
I think it's a very, very real threat and concern. And I don't say any of that lightly. And frankly, it's painful for me as someone who, has spent her whole life in Republican politics, who grew up as a Republican, to watch what's happening to my party and to watch the extent to which Donald Trump himself has, basically determined that the only thing that matters is him, his power, his success. And that is not somebody you can entrust with the power of the presidency.
It seems crazy to ask this and even crazier to fathom it. But do you believe if Donald Trump were elected next year that he would try to stay in office beyond a second term? That he would never leave office?
There's no question.
No question.
You think he would try to stay in power forever?
Absolutely. I mean, he's already...
All right, sounds pretty good. I mean, that's not a bad thing.
Already done it once. And in fact, if you look at what he did in the run-up to January 6th, in terms of his pressure on the vice president not to count legitimate electoral votes, his pressure on the Department of Justice, on state officials, and then refusing to send help when the Capitol was under attack, he's already attempted to seize power. And he was stopped, thankfully, and for the good of the nation and the republic. But he said he will do it again. He's expressed no remorse for what he did.
So she must really need to sell some books. I mean, she sounds like unhinged. I mean, really unwell that Trump is going to be a dictator, seize power. But did he leave last time? I mean, he packed up his stuff and left. You charge him with crimes for that. Like, you understand that? He's got an indictment against him in Florida because he's not the president. And now you guys are raiding everybody. You went through his wife's sock drawer. Okay, so that's Liz. She's having a tough one out there. And I think, I don't know if she's that demented or if she's just a faker, but I think she's dishonest either way. And this is what Trump said in response. And he was talking to her in response to some of her weekend commentary. Said, crazy Liz Cheney from Trump, who suffers from Trump's Trump derangement syndrome at a level rarely seen before, writes in her boring new book that Kevin McCarthy said that he came to Mar-a-Lago after the rigged election because, quote, the former president was depressed and not eating. That statement is not true. I was not depressed, says Trump. I was angry. And it was not that I was not eating. It was that I was eating too much. Oops. He was at Mar-a-Lago to get my support and to bring Republican Party together. Only good intentions from Kev. Liz Cheney, on the other hand, went on to lose her seat in Congress by the largest margin in the history of the U.S. I didn't realize that. She then worked with others on the J6 committee to delete and destroy the findings and the evidence from the committee. And so that's Donald Trump, absolutely right. It is true. TDS is reaching epic proportions, and Liz Cheney, she has a lot of it. So hopefully someone gets her some, sedition quill so that she can take sedition quill and relax, calm down over there. All right, so that's Liz Cheney. Now, this is the motion to dismiss being denied by Judge Chutkan. Stick around. Thanks for subscribing to our channel because we're going to see more motions to dismiss being denied right here from Judge Chutkan. A lot more, in fact. She's going to be denying. And so hopefully you join us as we continue to cover them because they'll be appealed and then the day will come. We'll be covering it, my friends. Thank you for liking this video. Thank you for subscribing. Thank you for checking out robertgovea.com to check out the daily newsletter. Sign up for that, and we'll look forward to seeing you on the next one.